Good afternoon, ladies and gentlemen. First of all, I would like to introduce myself. My name is Belinda, and I will be hosting the seminar today. On behalf of the organizers, I would like to extend my warm welcome to the Dean of the Faculty of Law, Brawijaya University, Dr. Muhammad Ali Safaat, and the distinguished speakers. First, Professor Simon Butt, Professor Rafael J. Heffron, Dr. Dina binti Imam Supaat, Dr. Indi Gurubani, Dr. Sinta Hadiantina. I also welcome all participants who attend this international seminar, Unraveling Access to Justice in a Time of Uncertainty, which is organized by the Faculty of Law, Brawijaya University. Ladies and gentlemen, on this occasion, I would like to inform you the agenda of the event. First, singing the Indonesian national anthem, and then the opening ceremony by Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, Brawijaya University, followed by the presentation that will be delivered by the 6 speakers. After that, we will open a question and answer session, which will be led by the moderator, Ms. Aulia Nabila. And finally, we will have a photo session before the closing of the seminar. The first event was singing the Indonesian national anthem. Ladies and gentlemen, to begin with, I would like to invite Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, Brawijaya University, to deliver his opening remark. Please welcome.
Thank you, Belinda. Here's all distinguished speakers, Professor Rafael Heffron, Professor Simon Butt, Ibu Dr. Dina Imam Subaat, Ibu Dr. Indi Gurubani, and Ibu Dr. Sinta Hadiantina, all participants and all committee of this international seminar on unraveling access to justice in a time of uncertainty. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. Alhamdulillah, thank you the Almighty God for the abundance of health of all of us. Hopefully everyone in here is always healthy and continue to carry out the activities. It is an honor for us, the Law Faculty of Universitas Brawijaya, to arrange and invite distinguished speakers and participants to this international seminar. As we know that the outbreak of COVID-19 has great impact to every dimension of human life, including law and justice. many limitations set up by the government to control the outbreak and to reduce the positive rate and fatality rate. And the greatest impact, of course, of that limitation is on the weakest people and social class, especially for access to justice. I believe this seminar will enrich and enhance our understanding on that issue, so we could find alternative mechanism for greater access to justice in its country, in Indonesia especially. I would like to express my gratitude to all distinguished speakers. I expect to invite all of you, Professor Heffron, Prof. Simon Butt, and Puan Dina to visit Malang, maybe next year or next 2 years physically after the outbreak. And thanks you also for all the participants that joined this seminar and for committee from Constitutional Law Department and Administrative Law Department. Thank you again, and Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Muhammad Ali Safaat. Now it is time for the seminar presentation that will be delivered by our distinguished speakers. This presentation session will be chaired by Ms. Aulia Nabila. She's one of the lecturers in the Constitutional Law Department, a bachelor graduate from the Faculty of Law, Brawijaya University, and a master's from the University of Groningen. Without further ado, please welcome Ms. Aulia Nabila.
Thank you very much, Ms. Belinda, for the introduction. The Honorable Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, the Honorable faculty members, professors, assistant professors, and staffs of the faculty, the Honorable speakers of today's seminar, and all of the participants of this seminar. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everybody. And also good morning and good evening to some of you. I hope you are safe and well wherever you are. And ladies and gentlemen, the title of today's seminar is Unraveling Access to Justice in a Time of Uncertainty. We are now indeed facing a time that affects each of us without exception. We are now facing this COVID-19 pandemic, which puts us in an uncertain position. We are uncertain, for example, of the exact number of the cases. We are uncertain of how we can actually cure this pandemic, and we are uncertain of when is this going to be over. And this is why the discussion of access to justice becomes more crucial, because this uncertainty makes each of us vulnerable, more vulnerable than before. And today we are going to look at this matter through different lenses of law. And we are very happy today that there are 5 speakers today joining us from different expertise of law. First, we have Dr. Dina Imam Supaat from the University of Science Islam Malaysia. And then we have Professor Raphael Heffron from the University of Dundee. And then we have Professor Simon Butt from the University of Sydney. We have also Dr. Indi Gurubani from Universitas Brawijaya, and also Dr. Sinta Hadiantina from Universitas Brawijaya. And actually, we are planning to have 6 speakers of this seminar. So the other speakers that we plan today is Dr. Adamantia Rakovitsa, but she unfortunately couldn't make it to the seminar today due to her health condition. So she requested to convey her apologies to the dean of the faculty, and then also to the participants of this seminar that she couldn't make it to the seminar today. And we hope that Dr. Rakovitsa can get well soon, of course. And so now we are beginning the plenary session of this seminar. So each of the speakers will present their topic for 20 minutes, and then we will begin the questions and answer session. And we will give the audience the chance to ask their questions, to present their question directly to the speakers. So you will be asked to turn on your speakers and your cameras as well if you would like to ask a question. And the first Q&A session will be for 3 questions. And if we still have time left, then we will continue to the second session of the Q&A, and then we will have a closing session in which the speakers will give their concluding remarks. And I think that's it about the sequence of the seminar. So without further ado, I invite Dr. Dina Imam Sufaat to present her topic. So, ladies and gentlemen, Dr. Dina is a senior lecturer at the Faculty of Sharia and Law, Islamic Science University of Malaysia. Her expertise includes judicial review of administrative action, customary norms, and international refugee law, and also enforcement of Sharia courts, orders, and customer issues. So, without further ado, I invite Dr. Dina Imam Sufaat to present her topic. Dr. Dina, time is yours.
Bismillahirrahmanirrahim. Assalamualaikum, and a very good afternoon to, thank you, Aulia Nabila, the moderator, and Assalamualaikum and good afternoon to the Dean of the Faculty of Law, Universitas Brawijaya, our fellow presenters, and also the audience, and the faculty members especially. It's a privilege to join all of you today. And Pak Dekan, I was there in Malang. I went to Malang twice last year. I love Malang a lot. I love the place, I love the people, I love the coffee as well. It was a very good experience. So when Raphael and Simon go to Malang next time, please enjoy yourself. So I will today, let me first share my screen. Okay. Okay, I will talk about, oh my God. So my topic would be on vulnerable people in Malaysia and their access to justice in this time of uncertainty. So in my discussion, I will speak briefly on the introduction and the scope and content of access to justice and the exceptional situations that intensify the demand for access to justice during the COVID-19 pandemic. I will discuss the access to justice for vulnerable people, some focus on that, and I will look at the way forward and also will conclude my presentation. So as everybody knows, the uncertainties caused by this COVID-19 is still unfolding. We thought, in Malaysia, we thought we almost win the battle, but we don't. The number in Malaysia today has yesterday has reached its highest, which is 871. When we had the pandemic last, the first few months, the first round, the first wave, it was only the maximum was 400 plus. And the second wave was worse than the first one. And we hope that wherever we are and whoever we are, we will go through this pandemic and become stronger. And the pandemic and its restriction of movement has a wide effect on everything, especially the access to courts and the proceedings. And its dominoes effect, the dominoes effect of the pandemic and the restriction of movement is felt in every realm of our life, including the business, economics, and we know that today the authorities have more powers affecting our rights as the citizen and the public, especially with the use of law to restrict our movement. Everybody knows what is access to justice, but I would like to just repeat that access to justice is the basic principle of the rule of law. If you cannot have access to justice, then we cannot fulfill the rule of law. Therefore, if we cannot have access to justice, people are unable to have their voice heard. They cannot exercise their rights, and they cannot challenge any discrimination or against themselves, and we cannot hold decision makers accountable for their conduct. And therefore, we consider access to justice as a guarantee to allow the people to get redress to whatever grievances that they have. It is also if we look at the writing and also research and also reports, we found many literatures responding to the COVID-19 by saying that it has a very significant effect to the functions of the justice system, not only to certain countries but also to all other countries over the world, because some courts are closing. Some might be able to open the courts, but nobody can attend the hearing, and we have to adjust the courts to accommodate the needs of the people, and also to sometimes to the movement restriction order by the authorities. So COVID-19, in short, has impacted not only the availability but also the delivery of the legal and justice service. So in Malaysia, before the COVID-19, we have tried to improve the access to judicial institutions, especially to vulnerable people. When we have vulnerable people who are, those people who are living very far from the city where access to court is better, and we have people who live in geographical challenge areas. So the government introduced mobile courts. When we talk about mobile courts, we have two types of mobile courts. Whether we use a vehicle that we convert into mobile court rooms, or we just move the court personnel, the magistrate, the commissioners of oath, and the court interpreter to a remote part of the country using boats or other vehicles, and including light aircraft. So this is already in place in Malaysia, especially in the states of Sabah and Sarawak. Sabah and Sarawak, for those who are not familiar with Malaysian geographical condition, is the east part of Malaysia that is that share a border. Its border is shared with Kalimantan, Indonesia. So that part of Sabah and Sarawak, because they are very big, it's a very big state. So they have people living in the jungle, or very isolated from the city. And we also have the new rules of courts 2012, which is considered as a simpler court process, so that more people will be able to access justice. So these are some of the things that Malaysia has already, which are already in place for Malaysia, that alhamdulillah have increased the access to justice for vulnerable people. And we also take note of the point made by our former Chief Justice in which he said that the legal profession must embrace technology. We cannot run away from it. There is no option to it. It has to be, we have to adapt to the technology in our legal profession. And therefore, the Malaysian government also, in its effort to resolve problems of delay and backlog of cases, we introduced a number of mechanisms, including e-filing, in which the filing of cases are made online. This is introduced in 2011. So parties can view the file from remotely, and we also have the video conferencing system. This has been used since 2011 too, in which they record the court proceeding, and then the recorded proceeding will be shared to the parties, and also especially for the use of the judge, so that he can refer to it, so that the judge do not have to jot down notes, and can concentrate on the parties. Last but not least, we have case recording and transcribing. So this is in conjunction with the video conferencing. Okay, I would like to highlight the relevancy of access to justice to the SDG. Maybe this is not the best time to talk about SDG. I just want to point it out, because SDG is supposed to bring us all together to achieve our prosperity now that there is the pandemic of COVID-19. Maybe it could affect our achievement of SDG targets. So access to justice is very crucial to SDG 1 and SDG 2, SDG 5, 14, 15, and 16. So it affects, especially if you look at SDG 5, it's very relevant to women, yeah? and women are part of those vulnerable people. And I would like to discuss the scope and content of access to justice. This may be different this could be different than what other people think, but this is what my perspective on this matter. Okay, so in Malaysia, our access to justice is guaranteed under the Federal Constitution, even though it's not pointed out, it's not spelled out expressly. It impliedly, scholars are saying that the right is guaranteed under the right equality, the principle of equality before the law, and that we are equally protected without discrimination. The fact, the non-discrimination principle. Even though access to justice might mean different things to different people, it in wider context, it refers to the court system and reducing the systematic barriers faced by the different members of the community. And actually, the access to justice is not only limited to court system, but other adjudication mechanism also is an aspect of access to justice. Okay, so as I mentioned earlier, the claim of access to justice also involves the invocation of Article 5, the liberty of person, and also Article 8, and it is also supported by a number of other scholars, including Vivalve in his writing in 2020, because as he said that access to justice is part of right to life. And however, the court in Malaysia was saying that access to justice shall only available to the extent that the courts are empowered to administer justice. So you cannot say just because something is out of court's jurisdiction, then then we say that there is no access to justice. So it depends. It still depends on what jurisdiction the court has. Okay, and the essence is the following. The first essence of access to justice is the state must provide an effective adjudicatory mechanism. The second one, the mechanism provided must be reasonably accessible in terms of distance. The third one, the process of adjudication must be speedy, so it should not take long time. The litigants' access, number 4, the litigants' access to the adjudicatory process must be affordable. If it's expensive or exclusive to certain people, we cannot say that there is an access to justice. And there must be an available remedies. It's very frustrating if you have some grievances, but the remedy is not there, is not provided under the law, except for things which is should not be remedied. Okay, the sixth element is that the capacity of individuals should not be affected by discrimination, such as your citizenship should not affect your access to justice, or your legal status, whether you are an immigrant or illegal immigrant, or whether you are a child or you're a woman. The procedure should be in the language of the community, and if the parties do not understand the language, then he should be entitled to an interpreter. This is another element of access to justice. And the eighth is the provision of quality legal assistance, service, or legal aid. This means there must be a provision made for people who cannot afford the cost of accessing the justice system. So we should have legal aid or equal service like that. And there is also a provision, there should be a provision of alternative means of conflict or dispute resolution. So if there is courts, there should also other alternative means for justice, such as the tribunal, or maybe the mediation in Malaysia, or under the Islamic justice, administration of justice will also have suluh, the Islamic version, the another name for mediation. Okay, so what is the situations that increase the demand for or that have affected the access for justice during this COVID-19? The first one is the emergency situation. Countries have imposed the state of emergency in their country, and if this has happened, it could affect people's access to justice for various reasons. Because during the state of emergency, some human rights, certain human rights obligation of the state can be derogated from. But I'm not saying that this could affect access to justice, but this will definitely affect access to justice. But it can, in some ways, it can affect the access to justice. However, no matter.
Dr. Dina, I'm sorry,
yes.
we have 5 minutes left.
Okay, I'll try to be very fast. Yeah? Okay, but the access to justice, the access to justice cannot be derogated from. Regardless of the emergency situation, we cannot derogate from the right to or the access to justice. Especially people can be, especially when during the pandemic, many things can happen. The authority have more power to detain people. So when you are detained, you would want to be brought to the court. So this cannot be derogated. This right cannot be derogated. Okay, we might want to challenge the legality of the detention due to the increased number of arrests, and especially today we have more domestic violence and child abuse cases. There was a dramatic increase. There were also cases where children being abducted by their own parents who take advantage of the border closed. And we have cases where children maintenance or the wife maintenance are not being paid, or children are left behind because the family take advantage to leave the children. Yeah? And we have problem of detainees at the immigration detention center. We have issues of layoff where employers just take advantage too. Yes, when they need to lay off, if the layoff is justified, is fine, but there are unfair compensation paid, then there should be a problem. So if the court is not in session, there will be a problem. Okay. We also have, I think we have what? The online business has increased very dramatically. So because of that, we have more problem with the consumers have more problems, very unhappy with the seller, some blatant seller or a scam. Yeah? So access to justice is very important. And in Malaysia, for example, we have services. We have children who wants to claim citizenship, and if the court is not in session, then they cannot claim citizenship, or the case will be will be postponed for a long time. Okay, so we thought, okay, the vulnerable people are people that I mentioned earlier, those people who can be affected as compared to some people, children, women, people who are sick, the elderly, poor people are those included in vulnerable people group. And children who women and children who are victims of domestic violence are also vulnerable people. Yeah, and I list down here the barriers of access to justice, including their physical incapacity, their concern of the cause, their long-standing ill health, their lack of expertise, their lack of knowledge. They don't know about their rights. They don't have this tradition of going to the courts. They have problem with the geographical factor, and also there is problem of corruption. Yeah, and public perception on justice system. So these are only example of vulnerable population, including stateless persons and pregnant women, people with HIV or AIDS. Yeah, and what do we do now? I would like to encourage everybody to read the book by Richard Susskind on online courts and the future of justice. It's a very good book that promote and which is very positive, very encouraging. The way he wrote the book make it sounds very possible to have online courts, full online courts, except for certain cases. So we have to have online courts. Okay, in Malaysia during the pandemic, we have online courts to some extent, but there are some problems and there are some supports for it, and there are also some disadvantage of it. Even though it's very accessible, convenience, it's cost and time saving, there is good opportunity for documentation, and we can use advanced technology. There is also problem with poor internet coverage, especially those who live in remote area. We have users who are not technology savvy, and how could we question the ability of the court to assess the demeanor of the witnesses in courts? And if the witness cannot stand the grilling of the lawyers, they might want to purposely turn off the internet connection, yeah? And we also see that this could endanger the traditional jobs. Yeah.
Okay, can we have the conclusion maybe for the
Yes,
presentation?
all right.
Thank you.
So, okay. So my conclusion would be we have to acknowledge that access to justice is already very difficult to some certain group, and this is exacerbated by the COVID-19 pandemic. And however, this COVID-19 has opened up an opportunity for us because it compels us to embrace the technology. We cannot tell other people it's not possible. It's not possible. No, we have to. We have to force ourselves. We have to move towards the online courts. And even though it has been improved, even though access to justice have improved in some ways, there are still issues related to it, such as the internet quality and also the issue of open trial. Yeah, I don't think people are ready to have Zoom, yeah, for hearing. Okay. We have to develop a justice system that is flexible to change. We cannot have a system that takes a long time to accommodate another needs. For example, that we have now. Before we can have online courts, we have to do so many things. It takes a long time before we can actually use the system. So we have to bear in mind that we have exceptional circumstances. Anytime it can happen, so we have to have exceptional measures to answer whatever problem that we have during that time. So that's all from me. Thank you very much.
Thank you very much, Dr. Dina, for the presentation about access to justice for vulnerable people. So let me summarize Dr. Dina's presentation for a bit in bahasa Indonesia actually. Jadi Dr. Dina tadi mempresentasikan tentang access to justice bagi kelompok rentan seperti itu, dan bagaimana COVID-19 ini memiliki dampak yang sangat besar, dan dampak ini khususnya lebih dirasakan oleh kelompok rentan atau vulnerable people tersebut. Dan disinilah kita membutuhkan integrasi antara teknologi dengan sistem peradilan yang diwujudkan dalam mobile courts atau sistem peradilan mobile atau sistem peradilan elektronik seperti itu. Dan kemudian Dr. Dina juga membahas mengenai esensi dari access to justice. Yang pertama terdiri dari pelaksanaan sistem adjudikasi yang efektif, kemudian aksesibilitas dari sistem tersebut, kemudian proses yang cepat, kemudian juga terjangkau, affordable, dan yang terakhir adanya remedies atau seperti ganti rugi bagi pihak-pihak yang mengalami kerugian, dan bahwa access to justice cannot be derogated, atau bahwa hak terhadap access to justice itu tidak dapat dikurangi dalam keadaan apapun, termasuk dalam kondisi pandemik seperti ini, dan bahwa vulnerable people atau kelompok rentan juga lebih rentan lagi dalam kondisi pandemik seperti ini, dan bahwa mereka juga harus menjadi kelompok yang diprioritaskan bagi keberadaan sistem peradilan elektronik. Dan ada beberapa juga pro dan kontra terkait dengan sistem peradilan elektronik, yang diantaranya bahwa beberapa kelompok masyarakat itu juga masih belum siap dan belum mampu untuk menjangkau sistem tersebut. Okay, that is my summary of Dr. Dina's presentation. So we are moving on to our second speaker for today's seminar, which is Professor Rafael Heffron. Professor Rafael Heffron is the Professor of Global Energy Law and Sustainability at the Center for Energy, Petroleum and Mineral Law and Policy at the University of Dundee. He primarily works on the issues of achieving a just transition to a low carbon economy and combines a mix of energy law, policy and economics. So without further ado, Professor Heffron, time is yours. You may present your screen.
Thank you. And can you hear me okay?
Yes, very clearly.
So I'm going to speak in the context of the energy sector, and let's say particularly focus on the issue of procedural justice and COVID-19 in terms of the energy sector. So I will start off quite broadly and then get more detailed. So, thank you very much for inviting me to speak today. And it's a great honor to continue to do work with the University of Brawijaya. And for those that know me from the university, I have been over there in Malang in 2018, also last year in 2019. So this will be the first year that I will not have been there for a while. So hopefully things will be better next year and I can look forward to going again in 2021. So there was a small introduction. I won't say too much except to look at the end there where I am a qualified lawyer here, a barrister at law, and I have interdisciplinary energy degrees from Cambridge and also in taxation from Oxford. And I have been a visiting fellow at different places around the world. So from the West Indies to Mozambique to America to London, Paris, and also in Australia. But I just want to make that point in that I'm trying to give a global view of the issue in terms of the energy sector and procedural justice and COVID-19. So very briefly, for those that don't know where Dundee is, we're at the very top of the UK, and we are just located there. And it's the reason we are located there is that's where a lot of the oil and gas of the UK was offshore. And that's where our centre that I'm part of, you can see in the background, the CEPMLP, the Centre for Energy, Petroleum, Mineral Law and Policy. And you can also see 43 years old this year, so one of the oldest centres in the world. But I'm going to talk about some of the challenges to the energy sector and particularly focus on that procedural justice. And I just wanted to relate some of the issues here. Most of you will recognize that image of New York. And if New York was underwater, it would be a very big issue. And I want to highlight that in terms of, the energy sector, things are happening to a big degree. And we have to remember the importance of the energy sector today. It's worth in many economies around the world, including in Indonesia, it is a significant percentage of your GDP. So globally in GDP terms, it's 10%. The only other sector that is as large is the health sector. So there is a clear relationship between energy and health. And we have to remember that in many of the international reports coming from the Asian Development Bank, coming from the International Energy Agency, the World Bank, they all state that we want a green recovery, or we want a more sustainable economic growth. And I want to make that link between energy and climate change and COVID-19. We have to remember that this is very important, that we do have justice in this debate and obviously procedural justice. So could you imagine if New York was underwater? New York is the home, the original home of the current president of the United States, Donald Trump, who may lose the election in a couple of weeks. Many of you are probably hoping he loses the election in a couple of weeks. But we have to remember this is affecting the world over. And I just give you another example of the city of Venice, one of the biggest, the most romantic cities in the world. I know that some people say there is different romantic places such as Bali in Indonesia, or maybe even Milan. But, we have to remember that this is an issue facing many cities across the world. And I then just highlight the issue facing yourselves, many of you in Indonesia. And these are pictures from Jakarta. And we should recall that in Jakarta last year, it was announced that it will be underwater by 2050. And we also had the announcement that there will be a new capital for Indonesia. It was announced, and my belief is already construction has begun to start on the new capital. So, these are issues that are very important, I think, when we think of the impact of the energy sector and as a result, climate change. And it's why justice, we need to see, more justice than ever before. And you can see here different forms of justice in terms of a new low carbon economy, the development of a new low carbon economy. The lawyers among you will all be familiar with distributive, procedural, recognition, restorative, and then a final form of justice, cosmopolitan, where people believe they are citizens of the world. And I just mentioned this one because one of your neighboring countries, Australia, has had a recent judgment, which may be referred to later as well. But in terms in particular of this procedural justice point, what we are seeing are on a global level, big change because of a rise in data. We have now more access to data than we ever had before. So we are able to hold, whether it be a government, an institution, or an energy company, to account more than we were 5 or 10 years ago. We also have access to more images than we ever had before. So think about those images of New York or Venice or Jakarta. And again, we are able to use those images. If something happens in different parts of the country, we can transmit that information. Everyone has mobile phones. If things happen in the energy sector in different places across Indonesia, we can identify, look, this has happened. They tried to bypass the legislation. What are we going to do? Here is the effect from this particular company. And both this issue of the rise in data and images has played a big role in the environmental impact assessment process. And the environmental impact assessment process is very important for procedural justice in the energy sector. It supports environmental impact assessment process, supports the public participation for citizens. It also supports the necessary access to information where there may be environmental degradation, so the environment may be damaged. The information should be available to the public. So when we think of these processes, this all leads to a greater demand for procedural justice. And we can see this last year in 2019, the environmental impact assessment process in Australia. They were able to determine that the project developer who submitted a lot of the information was not presenting accurate information. A lot of the benefits that the project developer said would happen as a result of the project were identified due to the amount of data that is now available, were identified as, being, let's say, thought of as exaggerated, that they weren't able to demonstrate that they would actually be true. And we can see the same scenario in Kenya. So this issue in terms of procedural justice and environmental impact assessments is happening, whether it be in a developed country or a developing country. And in Kenya, despite the option to build this very big project, energy is needed in Kenya to support economic growth, yet at the same time, the project failed because it was unable to get through the environmental impact assessment. Again, it was proven that the data submitted by the project developer was unreliable. Again, there were images shown of the behavior of different types of companies who were involved in the project, of their behavior in previous projects. Again, this is something we can see. We can see if some company is planning to develop a project in Indonesia, you can now look at its performance in another project in Indonesia or even in another country. So again, it becomes harder to get permission to build a project. So in terms of COVID-19, what I do want to say is that some of these issues that I'm talking about here, you can see down at number 3, EIAs and the legal action on environmental damage. Some of these issues were happening already in the energy sector. And what I'm making the point here is you can see that these were happening already in terms of economics or taxation, disclosure issues, environmental impact assessments. The UN Sustainable Development Goals were already mentioned by the previous speaker. But what I would be arguing is that COVID-19 is a further accelerant of these justice issues. By accelerant, I mean it's making sure that justice is going to happen even faster. People are considering justice even faster in the energy sector. So you could ask me the question, why are they considering justice faster? And in this infographic, the explanation is there. The reason they're considering justice faster is because they identify justice as a risk in terms of the project development. They identify justice as a key issue where if you don't have some level of justice, that'll increase the project costs because it'll make the project more risky. If you haven't tried to ensure that there is some public participation, if you haven't tried to ensure that procedural justice is happening to a high degree, this will mean that your project could be more risky, and in the end, you may not get full permission to develop your project. And what we have here is you can see the justice risks in the center circle, but you can see again, the main types of justice: distributive, procedural, recognition, cosmopolitan, restorative, and those forms of justice in the middle. And one of them there that I focused on, environmental impact assessments, in terms of the procedural justice issue, which is rising. And the less justice you have, the more risky your project will be, and that will drive up the costs of your project. And what COVID-19 is doing is making sure that justice is at the forefront. And I just finish off with a note to say, even across research in the big interdisciplinary journals, the world-leading journals, more people are focusing on this topic of justice. So I think as lawyers and everyone here today focusing on justice, definitely in terms of the energy sector, justice is, let's say, one of the biggest topics today. Everyone is talking about justice. 95% of the researchers talking about justice in the energy sector are not lawyers. So everyone wants to engage in this topic. So it is a fundamental topic in terms of energy research, and definitely in terms of international energy research. So I think your conference on this issue is very important to raise this issue of justice, and particularly procedural, where access to justice, to public participation and information is absolutely crucial. And you can see both in Australia and in Kenya, that the more access to justice in terms of information and procedure you give, the more likely we will end up with better options for a low carbon future. So on that note, I will finish. There is my email for anyone who wants to get in touch with me about any questions you have. I do have a range of papers that talk more on the different types of justice that I will be happy to share with anyone who wants, or with someone who wants to circulate them to everyone here today. I am afraid that I won't be here for the questions because I have to go and teach in 5 minutes, because today is the first full day of term. So thank you very much for the invitation, and I hope you enjoyed the talk, and feel free and be in touch. Thank you.
Thank you very much, Professor Heffron, for the presentation. Unfortunately, we can have more time today to discuss with you in the Q&A session, but as Professor Heffron has shown you in his slides, that he provides his email address. So if you want to contact further, if you want to stay in touch with him, you can send an email to him. And I will summarize his presentation in Bahasa Indonesia. So, Profesor Rafael Heffron mempresentasikan tentang challenges to energy sector in COVID-19, atau tantangan bagi sektor energi di masa pandemi COVID-19. Dan bahwa di sini kita sudah lama tahu bahwa sektor energi memiliki kontribusi yang sangat besar terhadap perekonomian di berbagai negara, tak terkecuali Indonesia, dan bahwa kita juga melihat adanya krisis energi di berbagai negara, dengan dicontohkan tadi oleh Profesor Heffron, bagaimana jika New York itu tenggelam, termasuk apabila Jakarta tenggelam, dan seterusnya, dan bahwa di sini kita semakin melihat perlunya sistem justice atau keadilan itu sendiri diintegrasikan atau dibicarakan di dalam sektor energi. Kemudian juga adanya COVID-19 itu sendiri sebagai akseleran atau sebuah faktor yang membuat keadilan atau access to justice di sektor energi ini semakin krusial seperti itu, dengan adanya data, kemudian juga gambar-gambar yang semakin sering di-share dengan adanya internet, kemudian juga awareness atau kesadaran dari masyarakat sendiri semakin meningkat, dan bahwa informasi dan partisipasi masyarakat merupakan faktor yang sangat penting dalam meraih keadilan di sektor energi. Demikian summary dari saya. That's all my summary of Professor Heffron's presentation. Now we are moving on to the third speaker of today's seminar, Professor Simon Butt, which is the Professor of Indonesian Law and Associate Director, Center for Asian and Pacific Law of the University of Sydney. He has a wide area of expertise, which includes Indonesian law generally, and also includes constitutional, criminal, civil, human rights, commercial, Islamic, and customary or adat law in Indonesia. And he also has publications on comparative law, and particularly in transplanting legal norms between jurisdictions. So, Professor Simon Butt.
Okay. Thank you very much.
Are you ready? All right.
Yes.
You can share your screen.
Thank you. Oh, yes. And thanks very much for inviting me to speak today. I'm very happy to have been able to do it. It's already nighttime in Australia, look, it's not bedtime yet, so I'm not going to fall asleep, but it forces me to give what I hope will be a particularly interesting seminar. But thank you to the Dean, to Aulia, to all of the members of the Constitutional Law Department. It is a great pleasure to be here to talk about access to justice in the time of COVID. I've got here a presentation that doesn't really deal with Australia. It's more about Indonesia. And when Raphael was talking, he mentioned COVID as an accelerant, COVID as something that can make situations that may be fragile or weak, even more fragile and weak. Everyone is understandably looking to address the problem of the pandemic, the health emergency, financial chaos, unemployment, these types of things. And some pre-existing problems can just get worse through neglect. What I want to talk about here is law reform priorities. And one of the reasons why I wanted to talk about this topic is that some of the most controversial laws that have been passed in Australia recently and that have been passed in Indonesia recently have come during the time of the pandemic. And some people in Australia talk about these laws as being strategically timed. Not that the Parliament knew that a pandemic was coming, but rather that this controversial legislation was pushed through at a time when it's very hard for the community to participate in debates or protests about the law. I'm thinking in particular about your Omnibus Law, but also in Australia, we've had many laws. There's one about the education sector, the tertiary education sector, that was passed very quickly. And the police have been very fast to quell dissent or protests about those laws, using COVID as a reason. And if you're interested, this happened at University of Sydney itself last week, where one of our professors, whose name is Simon Nasi in Indonesian, was pushed to the ground by police, assaulted by police, actually. And ironically, he is a human rights lawyer, one of the best and most well-known human rights lawyers in all of Australia. And he was looking at a protest at the university with some of his students because they were discussing and learning about the law of protest in New South Wales. Ironically, their lecturer, their professor, was someone who was assaulted and treated violently by the police. Now, one of the big problems in Australia is that we have a system whereby police can arrest and fine people if they're grouped together in numbers. I think it's around 20. If they're sharing a common purpose. So if everyone's walking down the street and there are 50 people on the street, they're all doing their own thing. They don't know each other. They're not going to the same shop, members of the same house, for example. Then police would not be able to arrest them because there was no common purpose. They had no tujuan bersama in what they were doing. With protests, it means that people who are trying to come together to, for example, protest against a new law or protest against some government policy, it means that if there are more than 20 of them together, they need special permission. That permission might not be granted because the government thinks that COVID might be spread at one of these protests. So it's really having quite a significant impact on the way that democracy is working in Australia. People are being really quite limited in the way they can come together to collaborate to push back against laws that they don't like. Now, returning to Indonesia, I mean, we have had in Indonesia quite a large number of controversial laws passed. Some you might think are strange to be treated as priorities by the government in these difficult health and economic times. Of course, last year we had the DPR trying to pass a new criminal code. That didn't work after very significant protests. We had KPK law amendments that were passed despite protests. And these amendments have probably significantly weakened the KPK, makes it more likely to be ineffective in handling corruption cases, or at least not as effective as it has been in the past. All eyes will turn to the Constitutional Court of Indonesia, no doubt, when it decides a constitutional challenge against the validity of that KPK law. There have been all sorts of other laws, a law on the Constitutional Court itself, which extends the tenure of judges who sit on the Constitutional Court. It's quite interesting, actually. In countries like Australia, judicial tenure and expanding judicial tenure is associated with greater independence, not as giving judges a gift to ensure their loyalty. It's the opposite. In Australia and many other countries, but in Indonesia it's seen as a gift and as a treat to judges, so that they are convinced to side with the government in controversial cases. This is the thing that some reformist groups have been saying is behind the motivations. And one of the main areas that reformists are worried about in terms of the Constitutional Court is, of course, the Omnibus Law, which I mentioned before. And Raphael was just talking a minute ago about AMDAL and how COVID can have some significant impact on procedural justice, environmental rights, and these types of things. Of course, the Omnibus Law has had a significant impact on AMDAL, or environmental impact statements, in Indonesia. I have not read the provisions of the Omnibus Law yet, but it's my understanding that AMDAL will not be required necessarily for all business permits, and only really high risk business projects will require one. And this is a really significant backward step in environmental protection, some would say. Now, one of the areas that I am most concerned about as an outside observer of Indonesia is the lack of priority on passing a new code of criminal procedure. We've had a rush to pass the criminal code, a rush to pass the KPK law and the Omnibus Law and the Undang-Undang Mahkamah Konstitusi dan lain sebagainya. But I think one of the real impediments to access to justice, whether in a COVID time or not, is the outdated code of criminal procedure. Now, I know that there have been many suggestions, but many drafts, in fact, of a new RKUHP, rancangan of a new code of criminal procedure. But for some reason, it has not been prioritized as I think it probably should have. And I think one of the problems that needs fixing is related to fair trials. And of course, talking about access to justice, there can't be access to justice where trials are not fair. And during a time of public emergency, such as pandemics, procedural safeguards are likely to be some of the first to be put to one side, particularly as the resources of law enforcement institutions become more and more stretched. Now, in terms of fair trials, I've noticed two things in my recent reading of judgments of courts of Indonesia relating to whether defendants are getting fair trials in Indonesia or not. And the first observation I would make is that I've seen an increasing trend of key defense evidence in many high-profile cases in Indonesia being ignored by judges. They seem to be much more receptive to prosecution evidence, even when there are really serious problems with that evidence. This is just a general observation. Of course, it doesn't happen in every case, but there are quite a number of very well-known cases where I think this has happened, and these will be very familiar to an Indonesian audience, especially an Indonesian legal audience. I'm thinking of, and these are some of the most controversial cases in Indonesian legal history, the Ahok case, where the former governor of Jakarta was convicted for blasphemy on the basis of a video that was doctored by someone who was later convicted for doctoring it. I'm thinking also of the Jessica Wongso case, where a young lady who lived for some time in Sydney actually was found guilty of poisoning her friend in a cup of coffee that she bought her at an upmarket cafe in Jakarta. But in that case, there was very little evidence to point towards Jessica Wongso. In fact, I don't think it was convincingly proved that she died because of cyanide poisoning. She could have died from natural causes. We have the Jakarta International School case, where a employee from Canada was found guilty of sexual assault of a minor, even though the evidence, I think, probably violated Indonesian evidence law. And the problem is, those are just three cases, but the problem is that when defendants appeal on the basis that their evidence and the arguments they have built based on that evidence was not addressed by the lower court, the appeals courts usually just say there was no error in the application of the law by the lower courts. Now, I've got some ideas about how some of these problems might be solved, and I'm happy to talk about them in the question and answers session. The second thing I've noticed in relation to fair trials is Indonesia's Dossier system. By dossier, I mean berkas perkara. Now, in Indonesia, in a criminal case, the defense is not entitled to view or to receive all the evidence that police and prosecutors obtain during their investigations. Prosecutors can choose what they use at trial and can include the evidence in the case dossier, which of course, as you will all know, they can then hand over to the court in the lead up to the trial. Now, police and prosecutors can simply not include in that dossier any information that doesn't help demonstrate the defendant's guilt. Now, of course, this will be to the disadvantage of the defendant if police-sourced evidence tends to show that the defendant was innocent. This might be evidence, for example, that the defendant had an airtight alibi, or even that someone else confessed to the crime. The defendant might not know about it, let alone be able to access information associated with that evidence. And this made me wonder how Indonesia came to adopt this dossier system. So I began making some comparisons with other civil law countries and some practices in common law countries as well. Now, although there's quite a lot of variation, in many civil law countries, an investigating judge or prosecutor is responsible for putting together a brief of evidence. And this becomes the primary evidentiary focus of a criminal trial, such that some trials are described as audits of the dossier. This is particularly common in France. The main purpose of the trial, from the perspective of the prosecutor, is to defend the evidence in the dossier that establishes the guilt of the defendant. And the defendant tries to cast doubt on that evidence. Now, critical to this process is that the investigating judge or prosecutor is highly professional, highly thorough, and extremely independent, and takes very seriously the function of collecting all of the relevant evidence that demonstrates the truth of what happened. Unlike a trial prosecutor, their role is not necessarily to demonstrate the guilt of the defendant. And to that end, they're required to include in the dossier any relevant evidence that both incriminates or exculpates the defendant. Now, of course, if that's the civil law system, well, the common law system is quite different. It operates particularly with different actors performing different roles and different presuppositions. Police.
Sorry, we have
5 minutes.
4 minutes left.
Thank you. Police and prosecutors produce evidence that points towards the guilt of the accused, and then the defense attempts to challenge that evidence and can put forward exculpatory evidence of its own. So it's more of an adversarial system, as of course I'm sure you're aware. But with no objectively compiled dossier as the focal point, prosecutors will prefer to adduce at trial only the evidence that is consistent with the guilt of the defendant. But because this can be unfair for the defendant, particularly if prosecutors have evidence that might be useful for the defendant, and they don't tell the defense about it. There are many countries in the common law world that have rules requiring prosecutors to disclose all evidence obtained during investigations to the defense. Again, the main purpose of these rules are to provide fairer trials and to prevent wrongful convictions. Now, I think in Indonesia, perhaps, a hybrid system has emerged. On the one hand, prosecutors produce dossiers for trials, just like in other civil law countries, but they're not required to be objective or professionally compiled, such as by investigatory or investigating judges or prosecutors, like in other civil countries. In Indonesia, the main function of prosecutors is to establish guilt, not necessarily to determine the truth of what happened. That is a judicial function. That's the jobs of the judges. So in Indonesia, then, the dossier will usually only contain incriminating information, but there's no counterbalance like we see in some common law countries. There's no right for the defense to see what's in the dossier. Neither party has a duty to assist the other. So defendants may never find out about the existence of very helpful evidence, such as an alibi or a confession. And I hope that one day this can be addressed in Indonesia. I know that in some versions of the draft KUHP, it's proposed that investigating judges or hakim komisiaris be established. But I'm not sure if this will necessarily solve the problem. Anyway, I hope what I've said today prompts some discussion, but I am really concerned about the presumption of innocence being compromised in Indonesia, and that in quite unprecedented times of a national pandemic, that it might be further compromised. I think that's all I've got time for now. Perhaps we can take up some of the points I've made in the question and answers. Thank Thank you very much.
Thank you very much, Professor Simon Butt, for the presentation. Jadi, Bapak, Ibu, dan saudara sekalian, Profesor Simon Butt tadi mempresentasikan tentang Law Reform Priorities and Fair Trials in Indonesia, atau prioritas dari reformasi hukum dan peradilan di Indonesia. Dan Profesor Simon Butt membahas mengenai secara spesifik mengenai sistem dossier atau berkas perkara yang diterapkan di Indonesia, dan di mana antara lain isu-isu yang terdapat dalam sistem ini adalah di sini berkas perkara digunakan sebagai sarana bagi penuntut umum atau penuntutan prosecution untuk establish guilt, atau di sini memperkuat keyakinan atau kebersalahan dari si tersangka atau terdakwa tadi, sehingga di sini terdakwa atau tersangka tidak bisa secara cukup seperti itu, secara seimbang untuk mengcounter atau melawan bukti-bukti yang terdapat atau dikemukakan dalam berkas perkara dan berkas penuntutan. Nah, yang menjadi menarik dalam konteks COVID-19 adalah apakah rancangan Kitab Undang-Undang Hukum Acara Pidana yang masuk di dalam agenda law reform itu akan dapat mengadres atau membahas, mendiskusikan mengenai permasalahan ini. Apabila terlebih lagi di masa COVID-19 ini, pemerintah dan legislatif bisa menghasilkan atau menghasilkan peraturan-peraturan hukum yang juga bisa beresiko terhadap hak kita atas sistem peradilan yang adil, di mana tadi Profesor Simon Butt juga mencontohkan seorang akademisi yang kemudian di sini di assault atau diserang oleh polisi saat sedang melakukan aktivitas akademik, karena di situ dia dianggap berkumpul dalam tujuan yang tidak dapat dibenarkan dalam peraturan hukum. Kemudian ada contoh-contoh yang lain juga seperti itu. Baik, we are now moving on to the fourth speaker of this seminar, which is Dr. Indi Gurubani. Dr. Indi Gurubani is the head of the Constitutional Law Department of Faculty of Law, Universitas Brawijaya. She is an expert in constitutional law, also local government law, and also mining law. She has numerous publications discussing mining law. So, without further ado, I invite Dr. Indi Gurubani. Dr. Indi, time is yours. And Dr. Indah will present her topic with a little mix of English and Bahasa Indonesia. So I will assist with some translations along the way.
Okay. Thank you, Miss Aulia, the moderator. I have to say thank you too for the committee for give me an opportunity to be a speaker in this seminar, and the Honorable Dean, I think our Dean is left from this link today, but I saw my lovely colleague, Miss Afifa, in this forum, and I think Miss Afifa is a friend from Prof. Simon, because in the same university in Sydney, and I have say thank you too for the honorable speakers, Ibu Dr. Dina Imam Supaat and Prof. Rafael Heffron. Rafael has left the room too, and Prof. Simon, we meet again because we have met in last week in constitutional law in 3-in-1 program, and Ibu Dr. Sinta Hadiantina, my lovely colleague, and in the administrative law department. Nice to meet you all in this forum for the participant in this seminar too. My topic today is about, sorry, I have shared my screen. My topic today is concerning making rule during the COVID-19 period in Indonesia in democratic political perspective. Sorry if my English not good, but I try to use English in this forum. Maybe Miss Aulia can help me to translate or to help me to make the participants understand what I mean in this PowerPoint. Okay, who am I? I think I have the same PowerPoint with Rafael, because I almost follow the seminar when the Rafael give the lecture. So I have some research with Rafael about the access to justice, but in mineral and energy in pandemic COVID. I have just finished my joint research with Rafael, but in this seminar I will talk about the concerning make rules for the all rules in Indonesia, but especially in Omnibus Law. In Omnibus Law, we will talk too about there is a paragraph about energy and mineral sector and nuclear sector in paragraph 5 and paragraph 6 in that rules, in that Cipta Kerja rules. But now I just want to explain about concerning make rules in Indonesia. Concerning making rules in Indonesia, regulated in two of law, but there is the second rules is the amendment of the rule. The concerning making rules in Indonesia regulated in Law of the Republic of Indonesia number 12 of 2011 regarding concerning making rules, and the second in the Law of the Republic of Indonesia number 15 of 2019 regarding amendment to Law number 12 of 2011 regarding concerning making rules. So there is just about the regulation concerning making rules in Indonesia. The philosophical basic and that step 2 in consideration in that law, that to realize Indonesia as a law-based country. So the state has obligation to carry out the development of a planned, integrated and sustainable national law in the national legal system that guarantees protection of all rights and obligation of the people of Indonesia based on constitution. That philosophical basis in that rule about the concerning making rules in Indonesia. So making rules is forming rules which includes the stage of planning, preparation, discussion, approval or determination, and promulgation. This is the definition about making rules in Indonesia. In that law, in the law of number 12 of 2011 regarding concerning making rules, there is a chapter about principle of making rules. There is in Article 5 state that making rules should be done based on the principle of good making rules, which include clear purpose and made by proper agency or official, made between the types, hierarchy, and the contents, and can be implemented, versatility and result, and clear formulation, and last, openness. This is the principle of making rules in Indonesia stated in the Article 5. And in the Article 6, still in principle of making rules in Indonesia, state about the contents of rules should reflect the principle of one, the most important is protection and humanity, nationality, family, character of Indonesia, unity and diversity, fairness, equality position and law and government, order and the certainty of law, and or balance, math, and harmony. And the second paragraph, that is, in addition to reflecting the principles, certain rules may contain other principles in accordance with the field of relevant rules. This is the Article 6 state about principle of making rules in Indonesia in law number 12 of 2011 regarding concerning making rules in Indonesia. And that law, there is a chapter about public participation in the Article 19 and 6 that state people have the right to give input orally and or written in the making rules. There is the paragraph 1, and in the paragraph 2 explain about how people to give input. There is can be verbal or written input can be done through public hearing, working visit, socialization, and or seminars, workshop, and or discussion. So in the paragraph 3, people, the means of people here is people is an individual or group of people who have an interest in the substance of the draft of regulation, and how to facilitate it in the paragraph 4, to facilitate the public to provide input verbally or written input. Any draft of regulation should be easily accessible by the public. So we can make a cross for this paragraph in paragraph 4 in this chapter about public participation. So the regulation should be easily accessible by the public. Now, the fact in Indonesia today. The participant of the seminar can look at the BBC website. The title of the headline is about it at 8 October. The title is about 1,000 protests against Omnibus Law on jobs. Tens of thousands of Indonesians has protested against a controversial law that critics say will harm workers and the environment. I think Simon is just explained too about the Omnibus Law and before me, but the PowerPoint means to show the participant about how concerning making rules in Indonesia and regulated, and how the case or the fact in Indonesia today about concerning making rules. I think we can look the fact from the BBC article in this PowerPoint, but we we know who opposes the bill, who opposes the RUU Cipta Kerja. There is a coalition of 15 activist groups, including trade unions, condemned the bill and called on workers to join a planned national strike. So this is how regulated in the article about or paragraph chapter about public participation. And the protesters have demanded the government revoke the bill, and international union and human rights groups have commended it. So, how the RUU Cipta Kerja in Indonesia dibentuk and or concerning in the making rules RUU Cipta Kerja, there is not concerning with law of number 12 of 2011 regarding concerning making rule, but there is some hidden agenda in this RUU Cipta Kerja. So, in my opinion, RUU Cipta Kerja does not dibentuk or made by the political democracies or not democracies in the lawmaking. So this is the picture from BBC website about the protests against Omnibus Law on job. We can read and we can know about the explanation why they protest and against Omnibus Law. And some of explanation from people who against the Omnibus Law, because the Omnibus Law doesn't the Omnibus Law not melaksanakan Artikel 5, Artikel 6, and Artikel 19 and 90 and 6 in rule of concerning making rules in Indonesia. So my recommendation for this problem, to meet the people needs of the good regulation, it is necessary to the government and law representative to make regulation concerning making rules that are implemented in a sure and standard way and method, and binding on all agencies authorized to make the rules. And the second, to realize Indonesia as a law-based country, the state has obligation to carry out the development of a planned, integrated, and sustainable national law in the national legal system that guarantees protection of all rights and obligation of the people of Indonesia based on the Constitution. So that is my recommendation, and this is the end of my PowerPoint for this seminar. So we can discuss about this in after all speakers explanation the PowerPoint. Okay, thank you, Miss Aulia. Time is yours.
Thank you, Bu Indah. So I will summarize Bu Indah's presentation in few sentences. So Dr. Indah presents a topic concerning the lawmaking process during, especially during the COVID-19 pandemic, which has a lot to do with the Omnibus Law that has been in huge scrutiny in Indonesia, in which the law was passed and adopted during the pandemic and receives many accusations of not being in accordance with the principles of democracy, and also that the House of Representatives and the government uses these moments of pandemic to avoid the scrutiny, the bigger scrutiny of the society, since there are some prohibitions of gathering in large numbers, and which also has some relations with Professor Simon Butt's presentation about how the law in these times can be used by the authorities to prosecute, to punish people who do gatherings, even though they have clear intentions to, they have crucial issues to discuss. And Dr. Inda's presentation concerns the rules of lawmaking in the law number 12 of 2011 of lawmaking in Indonesia, and especially in Article 5 concerning the principles of lawmaking, and also Article 6 as the principles of the contents of the law that should be upheld in the process of lawmaking, and also the principles that have, and also rules of public participation or society's participation in lawmaking, which is regulated under Article 96 of the law, and that the Omnibus Law, Undang-Undang Cipta Kerja, tidak sesuai dengan prinsip-prinsip atau asas-asas demokrasi, dan ini berkaitan, dapat dikatakan berkaitan dengan terjadinya protes atau demo besar-besaran yang tadi sudah dicontohkan Ibu Indah di artikel dan di gambar yang ada di slide beliau, dan bahwa proses drafting atau perancangan pembentukan dari Undang-Undang Cipta Kerja ini juga tidak sesuai or inconsistent with Article 5, 6, and also 96 of the Law Number 12 of 2011 concerning lawmaking. That is my summary for Dr. Inda's presentation. And now, last but not least, we are having our fifth speaker of the seminar, Dr. Sinta Hadiantina. She is the head of the Quality Assurance Center of Universitas Brawijaya, or Pusat Jaminan Mutu. She is an expert in administrative law, especially in tax law and licensing law. So, Dr. Sinta, without further ado, time is yours. You may present your screen. Or is it the committee who will present the screen?
No, I will share screen myself.
Okay.
Thank you very much for Ms. Aya. Good afternoon, ladies and gentlemen. I'm Sinta Hadiantina. I'm from Administrative Law Department, Faculty of Law, Universitas Brawijaya. I would like to share my screen. Okay, thank you. I'm very happy today. I'm so excited and grateful to be here. Today we all have gathered here to discuss about a very interesting topic. My topic is the new normal acceleration of public service in licensing sector from an administrative law perspective, because I'm from administrative law department. Hopefully the discussion could be open your mind and inspiring for your research. Okay. Here are the points of our discussion today. Firstly, why am I interested to this topic because of the coronavirus disease and 19 pandemic brings negative and positive impacts. So that many policy and regulation that must be implemented. Okay. I think the citizens have a right to get public service. From birth to death, a citizen always connected to government. The government has a function to protect the citizens. In implementing public service, the government has a grand design, bureaucratic reform, which can be found on Presidential Regulation number 81 in 2010 of National Bureaucratic Reform Grand Design. But in the middle of the bureaucratic reform process, the COVID-19 pandemic occurred. Here the government function, firstly, service, second, regulation function, the third, development function, fourth, empowerment function, fifth, protection function, and the last is controlling function. Here is the bureaucratic reform. The main goal of bureaucratic reform are renewal and change to become good government. So I think it is very important about good governance. Next, nowadays, bureaucracy in Indonesia is entering final phase. This final phase will be very determined success of Indonesia to prosperous country with good and clean bureaucracy. In the third phase, the final phase, bureaucratic reform roadmap focus, priority, implementative, and collaborative. Okay, bureaucracy reform that have been implemented are experiencing obstacles due to this pandemic COVID-19. Mostly, the whole world pretended. And this is the Mr. President said, so we must live side by side with the COVID-19, make peace with the COVID-19, which means we don't give up but adapt. Public safety remains a priority. Okay. Here is speaking of public service in accordance with Article 1, Paragraph 1 of Law number 25 in 2009 on public service. It is stated that public service are activities or series in the context of meeting service needs in accordance with statutory regulation for every citizen or and resident of goods, service, and or administrative service. I think Based on this definition, the fulfillment of public service activities has been regulated based on regulation made by the government with the main objective of meeting basic needs and welfare of the community. Like Ibu Indah explained about the regulation. The first line is the circular letter about work from home policy. So the minister, state apparatus make a circular letter about work from home policy. And the second line, the new normal policy. Okay. This is the adjustment of the state apparatus work system to make effort to prevent the spread of COVID-19 in government institutions. State apparatus can implement work from home, but the decision maker officer must ensure there are at least two levels of the highest structural officer to carry out their duties in this office, like the dean, maybe. Okay. And then the second point, I think the state apparatus is obliged to report to their direct supervisor. And then the meetings are held online, like today, maybe. All face-to-face events with a large number of participants were postponed or canceled. The domestic official trips are carried out selectively. Foreign official trips are postponed. And the last is, I think, sterilizing the work environment. Okay. There is a lesson behind the COVID-19 pandemic that's happening now, especially in encouraging the acceleration of bureaucratic reform in Indonesia. The implementation of the work from home system for state apparatus marks a new chapter of shifting the way of working or entering an abnormal situation, carrying out their daily duties. Work system adaptation means flexibility in determining the work location. So we can choose work from home or work from office. Government can regulate the number of employees who are doing official duties in the office or not. And the human resource management apparatus doing performance evaluation, monitoring, and supervision, employee discipline. So I think this point is very important about the infrastructure support must be optimizing the use of integrated information technology, paying attention to information security and cyber security, adjusting a safe work environment from the spread of COVID-19. Nowadays, licensing procedure improving online system, like Prof. Heffron said, both using the website and application. Okay, here are the example. This is the procedure of oil and gas licensing. Maybe Dr. Indah very expert about oil and gas study. And then this is the procedure. So you can access to website or application. This is, I think, it's very important about the online single submission for business permit. You can open the website and then you can search the standard operating procedure to apply it. Okay. This is the procedure. This is the website in Jakarta. But sometimes the online system can cause errors sometimes, like this. This is the negative causes using online system, but it is easier because anyone can access anytime and anywhere. I think so easy. Okay. And this is the regional website for applying the license in Bandung, Malang City. Okay. This is the problem about the online system and for the public service. Maladministration, it's very important. I think according to Article 1, Paragraph 3 in Law Number 37 in 2008 on the Ombudsman Republic of Indonesia is defined as behavior or action against the law beyond authority, using authority for purpose other than those for which that authority is intended, including neglect of legal obligation. In the administration of public service carried out by state administrator and the government, which cause material and or immaterial losses to the public and individual. Okay. Okay. This is the maladministration potential. Okay. In public service on licensing sector. So you can see it. So the deviation procedure, ignore legal obligation. Okay. Okay. In Indonesia, Ombudsman is a state institution that has the authority to supervise the implementation of public service. Here, in Article 7 of Law on Ombudsman Republic of Indonesia, this is the duties. Here the
sorry, we have 4 minutes left.
Okay, thank you. My perspective about the new normal. I think I see the positive impact of a pandemic. So you can see that too many creativity and the new innovation. I think change in the government behavior and culture, flexible working arrangement, virtual presence, connectivity, work-life balance. Face-to-face services are transferred into online. I think this is very important. Okay, the synergy and collaboration across sector. I think now the positive impact of pandemic like that. This is my conclusion. I think the COVID pandemic not only had a negative impact, but also a positive impact on bureaucratic reform. And the COVID-19 pandemic forced the government to carry out a grand design of bureaucratic reform as a whole, forced the government to continue the innovate in the public services. Okay, thank you very much. Maybe we can discuss about this. Time is yours, Miss Nabila. Thank you very much for listening.
Thank you very much, Bu Sinta, for the presentation. Okay. So to summarize, Dr. Sinta presented on the acceleration of public services in the licensing sector from an administrative law perspective, in which she discussed about how the government systems have to adapt during the pandemic. Jadi Ibu Sinta mempresentasikan tentang bagaimana sektor administratif di pemerintahan seperti sektor perizinan seperti itu beradaptasi secara keseluruhan dalam masa pandemi ini, di mana salah satunya integrated technology itu harus dimaksimalkan sebagai salah satu cara beradaptasi. Akan tetapi masih ada resiko maladministrasi di masa pandemi ini, diantaranya seperti praktik-praktik yang tidak transparan, kemudian adanya penyalahgunaan wewenang dan seterusnya. Dan di sini juga bahwa masih ada dampak-dampak positif dari pandemi COVID-19 ini, di mana sektor-sektor pemerintahan kemudian juga dituntut untuk berinovasi, kemudian bersinergi antara satu dengan yang lain, kemudian memaksimalkan pelayanan secara online, termasuk di sini layanan-layanan pengajuan perizinan seperti itu, kemudian perubahan-perubahan di dalam kultur pemerintahan dan perilaku di lembaga-lembaga pemerintahan seperti jam-jam kerja dan kultur kerja yang lebih fleksibel. Dan itulah tadi sebagian presentasi dari Ibu Sinta. Okay, ladies and gentlemen, now we are beginning the Q&A session of the seminar. So in the first session of the Q&A, we will give chances to 3 people of the audience, and the audience who have questions to the speakers can raise their hands first, and then you can unmute your microphones and turn on your cameras so you can talk to the speakers directly and present your questions. Okay. Does anybody have questions to the speakers? I'm trying to go through the list of the participants here. Okay. We also, in fact,
I think very clear.
Yes. Yeah, maybe the audience immensely paying attention to the presentations. So, okay, I will try to go through the comment session of the YouTube as well, and the chat rooms. Okay, there is a question to Dr. Dina. So, has the Malaysian government prepared protection for vulnerable people in this crisis? So maybe we can start with this question, Dr. Dina.
Okay.
The special,
Thank
maybe,
you.
is there any special mechanism of protection to vulnerable people?
Thank you, Ms. Moderator, and thank you for the question. The question was about whether Malaysian government has prepared anything to help the vulnerable people. So far, we have not, due to COVID-19, specifically related to COVID-19, we have not done any special effort for vulnerable people because the government is continuing its effort to have online hearing. So anyone involved without exception, we have to go through the same procedure. However, the usual aid and assistance available for vulnerable people would be the legal aid provided by the Department of Legal Aid Services, Department of Legal Aid, yes, whereby people who cannot afford to pay a lawyer for a hearing will be provided by the government. The cost will be paid by the government, and if you are involved in criminal cases, especially a charge involving capital punishment, even if you do not want a lawyer, a court will provide one for you. So at the moment, there is no specific arrangement, but I am just raise the issue of how people can be affected, vulnerable people can be affected by the situation of the pandemic or other situation that affect their vulnerability and access to justice. I hope that answer your question, yeah?
Thank you, Dr. Dina. Maybe other speakers also wants to give their comments to this question. So this is about how vulnerable people are more to violations, human rights violations, especially during the pandemic. And is there maybe Professor Simon Butt, how is it in Australia? Is there any specific arrangement or mechanisms?
There probably is. What the main response of the government has been to give money to people who have lost their jobs and to people who are looking for jobs. And this has cost quite a lot of money. Many people have been paid for several months so far. But the idea behind the payments is to keep businesses open that might need to temporarily not open their doors due to COVID. So the idea is that these businesses will not necessarily go bankrupt because they can still afford to pay their staff, well, because the government is essentially paying their staff for them. So that has, I think, had a very significant impact on the economic system of Australia, particularly people who might otherwise have had a lot of trouble paying their bills and may have become homeless.
Okay, thank you, Professor. So in Australia, apparently there is a special scheme for people who became unemployed during the pandemic. And here we can also consider the unemployed as vulnerable as well in this time, since the COVID pandemic also severely affects the economic in each countries. Maybe other speakers, Bu Sinta or Ibu Indah, if you want to
Yes.
comment. Yeah.
Yes, I think the same situation in Indonesia. Maybe for my case about the sometimes the now the artificial intelligence maybe using in the other countries maybe, but in Indonesia like the public service, I said too many application and then website. I think make the unemployed too.
Okay, thank you, Bu Sinta. Maybe Bu Indah also wants to give some comments to the question.
Can Miss Aulia give some explanation in bahasa Indonesia?
Jadi tadi ada pertanyaan terkait dengan apakah ada mekanisme tersendiri bagi kelompok rentan dalam konteks perlindungan di masa pandemi COVID-19 seperti itu, Ibu.
I think in Indonesia, if we look from some case about the how the minority or the kelompok rentan is protect in Indonesia in pandemic era, I think that is not some regulated about that. Just some just still
Winda? Hello? Maybe there are some technical issues experienced by Winda right now. Maybe we can continue to the next question. Is there anybody who have questions to the speakers? You can directly ask the question either in English or Bahasa Indonesia. Okay. Okay, there is a question to Dr. Sinta. So the question is, what do you think when all licensing arrangements must go through information technology? Will it have an impact on the number of human resources who do not work and all of them will be replaced by computers?
Okay, thank you very much for the question. I think, to be honest, when a worker is no longer working as he should, I think he can develop himself to help others. Use of information technology, but I think human power cannot be replaced by machine, I think, except artificial intelligence. Maybe next year, or I don't know, in Indonesia, I think.
So in this pandemic, I guess we should use this chance to develop and enhance our skills.
Yes.
and also with technology, I guess we will never know what will happen. There is AI and everything, and I think it will continue to develop regardless of the pandemic. And yeah, I think we should now maybe focusing on the positive sides of the technology, in which helps us a lot in continuing to work and with our activities in the pandemic. Maybe other speakers, if you want to give comments to the question about how maybe the technology can replace human powers. Will it makes us humans become more vulnerable even, or maybe we can lose more? What else?
Nyuci piring weh.
Hello. Hi. I have a question.
Hi. Okay.
Yeah. Can I just turn off my camera?
Okay. Yes.
Yeah. I'm sorry.
Please introduce yourself and to whom your question is or are directed to. Thank you.
Oh, okay. My name is Nora. Sorry. Hello, my name is Nora. I come from Batam, Indonesia, and I think I have a question for the panelists, maybe Mrs. Sita, or Buandina. What do you think about the accessibility of the justice in pandemic era? I mean, like, we know that the society in Indonesia and also in Malaysia is pretty same. I mean, like, the justice is quite unreachable for the especially for the poor people, and now during the pandemic we are forced to digitalize everything, like Puantina said previously that Malaysia start to make a kind of mobile court and etc. And do you think that if we digitalize the court and make a kind of court mobile, the justice will be more reachable and the justice will be more accessible for the poor people? That's my question. Thank you.
Thank you, Ms. Nora, for the question. So the question is about the accessibility of the justice system, and if the technology will make the justice system, the court, and etc., more accessible, especially for the economically troubled people in the society. Maybe Dr. Tina want to answer the question first.
Okay, Assalamualaikum. Thank you for the question, Nora. Yes, I agree with you that if we provide more court services or judicial services in a way that is reachable for the vulnerable people, we would increase their access to justice. Because access is not just about our capacity to use the service according to our knowledge, but also the physical capacity, whether you have the capacity to access, to have physical access to the courts. That is why we need a mobile service, because without it, there are things that cannot wait. For example, we have cases born out of a born
Dr. Tina, hello? We lost you apparently. Dr. Tina, can you hear us? It seems that Dr. Tina have some connections issues.
Okay.
Oh, okay, you're back.
You hear me?
Yes.
Okay. So what was the last thing you hear from me?
I think it's about some things that cannot wait if we don't have mobile access to the justice system.
Oh, yes. Okay. All right, true. I agree with the fact that if we increase, if we make a courtroom or judicial services more accessible, nearer to the vulnerable people, we can increase their access to the courts. There are many things in our life that cannot wait, especially when we talk about children and we talk about vulnerable people. The children, for example, the children in Malaysia, for example, needs to prove that they have a birth certificate in order to be recognized as a citizen, and then in order to go to school. So sometimes they are street children, whereby their parentage, their parents cannot be proved. So they cannot go to school. But we cannot wait, because as we wait, the children could waste years of their time before they can go to school. So we need some sort of mobile courts to determine whether these children are actually a Malaysian citizen, whether they are actually born, they were given birth by a Malaysian parent. Because in Malaysia, if you are a woman and you are a citizen, but you got married with a non-citizen, you cannot give your citizen right to your children. So your children cannot become a citizen. But if you're a man, that is some sort of discrimination. If you're a man, a citizen, and you got married with a woman, non-citizen, you can pass your citizenship to your children. So the problem is when you cannot determine whether this child was a Malaysian children, you have to wait, you have to bring the child to court. But sometimes you cannot afford to bring the child to court for many reasons, for whatever reasons that you have. So the court have to come to these children. Yeah, the court have to come to these children. So I agree with you. For vulnerable people, access to justice is one of the things that must be guaranteed, must be respected, must be realized, because this is how they can continue to enjoy their other rights. It's not only about their education, later it affects their other rights as well. And please allow me to answer the first question, because when the first question came up, I heard that it was the access to justice, but it was actually the assistance. Malaysia spent, I think, about they reserve about 15 billion to help the people to recover from the COVID-19 effect, and about 50 million of that, no more than that, was specifically for vulnerable people. when the government talk about vulnerable people, that only covers elderly people, the indigenous people, the poor. But in our opinion, in the researchers' opinion, the vulnerable people also includes people who live below the poverty line, and also many other vulnerable group, including migrant workers and non-citizen, including the stateless children. So I hope I answer your question, yeah, Nora?
Okay,
Thank you.
thank you.
Yes, Wanita, thank you.
Thank you, Dr. Dina. And next, maybe Ibu Sinta, maybe you have some comments regarding how technology can enhance the licensing process, licensing application. Maybe can it be more accessible to the society who maybe want to apply for some license?
Okay, thank you very much for the question, Miss Nora Nuraini. Assalamualaikum warahmatullahi wabarakatuh. I think speak of justice, we are talking about how all parties get their due. In a pandemic like this, what must be priorities is how they should get their rights properly. In my opinion, good use of information technology can get them right, and all of that must have the support of all parties, government and society. I think this is my opinion, Miss Nora.
Okay,
thank you very much.
Thank you, Bu Sinta. Maybe Bu Indah ingin memberikan komentar juga bagi pertanyaan dari Nora, Mbak Nora. Jadi bagaimana teknologi, apakah teknologi dalam konteks pembentukan perundang-undangan mungkin seharusnya dapat memberikan akses lebih kepada masyarakat atau memberikan kesempatan bagi masyarakat untuk bisa berpartisipasi seperti itu, dan bagaimana konteksnya dalam kondisi sekarang di Indonesia?
Ya, saya mohon izin. Sorry, I will explain with Indonesian language. Sorry, Simon. Sorry, Budina. Maybe the moderator can help me to explain in English version.
Yeah, sure.
In my opinion about bagaimana seharusnya memanfaatkan teknologi di dalam masa pandemi ini, di dalam proses pembentukan peraturan perundang-undangan. Jadi ada beberapa penelitian yang sudah dilakukan, dan itu juga dilakukan oleh dosen dari Hukum Tata Negara, Fakultas Hukum Universitas Brawijaya, ada Bu Priska dan tim yang sudah melakukan penelitian terkait bagaimana seharusnya memberikan masukan ke DPR sebagai lembaga representatif atau lembaga perwakilan rakyat untuk kemudian menerima atau mendapatkan masukan dari masyarakat terkait dengan pembentukan peraturan perundang-undangan tapi di masa COVID ini begitu. Dan ada beberapa penggunaan teknologi yang bisa digunakan, dan ini juga sudah pernah dituliskan oleh mahasiswa kami, skripsi yang berjudul tentang petisi daring begitu. Jadi kalau tidak salah ada petisi mekanisme partisipasi publik dalam bentuk petisi daring yang bagaimana kemudian membangun sistemnya itu nanti dikerjasamakan dengan lembaga dalam hal ini lembaga legislatif yaitu DPR. Bagaimana kemudian petisi daring ataupun kemudian partisipasi publik ini dalam bentuk online itu diberlakukan dan menjadi bagian dari sistem bagaimana kita menyikapi COVID ini. Itu mungkin dulu yang bisa saya sampaikan. Tapi terkait lengkapnya itu nanti insya Allah akan bisa dilihat nanti di publikasi karena ada kewajiban publikasi untuk penelitian dimaksud begitu.
Okay, thank you, Bu Indah. So Bu Indah explained that technology indeed should have more impact or should enable more access to public participation. And in this case, she gave an example with a research that has been conducted by a student which is about an online petitions as the mechanisms of public participation, in which this online petition is used as the media of conveying aspirations or maybe even critics to the House of Representatives. And this is could be one way to give aspiration and express to give some sort of statements maybe as the general public. Some also maybe symbolizes some kind of public opinions that is quite different than some mechanisms that that I would say more popular in Indonesia. So yeah, I think that was Bu Indah's explanation. Yeah, this online petition can be seen as some form of innovation in democracy. Professor Simon Butt, maybe you have some comments on how is the role of technology in Australia in enhancing access of justice, especially in the context of the pandemic. Maybe there are some explanation you want to discuss.
Yes, not really very much compared to the other speakers, not much to add. I mean, many of the licensing systems were already largely online beforehand, as far as I know. One thing that has emerged is the extent to which criminal defendants should be required to appear via video link, and indeed whether video link is an effective way of hearing the evidence of a witness in a case. Many people in Australia are very concerned about whether witnesses can be properly cross-examined. So whether if a person appears via video link, the questions can have the same effect in terms of whether they are tajam or not, can try and force someone to answer a question. It's much easier to evade a question if you are on electronic devices. There's no pressure of the courtroom when you're by yourself, and it's quite easy to evade a very tricky line of questioning. And some people think that's not fair because the whole criminal justice system is designed around testing people and trying to determine their credibility as witnesses, and that's just too hard on video link. So that's what some of the people have been saying, but at the same time, we have, for various reasons, been using video conferences for court cases already. Some people who are in prison might give evidence from prison using a video uplink, and that has been happening for quite some time anyway. One of the other problems is, and it's associated with COVID, is the fact that it's now more difficult to have jury trials because you have a number of people coming together and discussing a case, and there's a risk that if one of them has the virus, that it might be passed on. So lots of smaller challenges to the criminal justice system, but including this idea of technology.
Okay, thank you, Professor. Okay, ladies and gentlemen, unfortunately, we've reached the end of the Q&A session, also the end of this event as well. But before we close the event, maybe the speakers have any concluding remarks, maybe starting from Bu Sinta. Apakah ada kesimpulan yang ingin disampaikan atas seminar hari ini? Or if not, Dr. Gina, do you have any concluding remarks? I'm sorry, your microphone is still muted.
Okay, sorry. Thank you, Aulia. My concluding remark would be on the issue of the artificial intelligence that we are going to use, inshallah, very widely in our justice system. There may be concern that the AI would replace human, but remember, AI has to be maintained. We still need human in that process. They will not be able to replace all of them. There are still many aspects of the law, many aspects of the legal practice, the judicial system that needs human touch, that cannot be replaced by the AI. But most importantly, from the presentation and from our conference today, I would say that access to justice is the right that we have to respect and we have to protect, because many people will be affected if we fail to ensure that justice can be accessed by everyone, regardless of their status, regardless of their capacity or economic and social background. Thank you.
Thank you. The next speaker, Ibu Indah, Dr. Indah, if you have some concluding remarks.
Okay. My conclusion is, to meet the people needs of the good regulation, it is necessary in pandemic era to make regulation concerning making rules that are implemented in a sure and standard way and method, and binding on all agencies authorized to make the rules, and all the state has obligation to carry out the development of a plain, integrated, and sustainable national law in the national legal system that guarantees protection of all rights and obligation of the people. That's my conclusion.
Okay, thank you, Indah. Next is Professor Simon Butt.
Yes, the main theme from my presentation, I suppose, and I think also Inda's, is the need to be participatory in lawmaking as well as criticisms of laws that have been passed. Now, COVID, as I said in my presentation, gives governments an excuse, a reason to prevent people coming together to kind of criticize laws. And there's a balance, isn't there, between public health and democracy. And it's a very difficult balance to strike, but it's an important one to get right, because hopefully the pandemic won't last forever, but laws can last for a very long time. And so once a law is passed, sometimes it's difficult to revoke it. I really hope the pandemic ends soon, that we have a vaccine coming soon, and we'll look back on this time as being a very difficult period, but it can end. I really hope that. So thank you very much for the seminar, and I want to come to Indonesia next time, not do it on Zoom.
Yes, please. We will look forward to it. And Bu Sinta?
Thank you very much for moderator. I think the COVID-19 pandemic not only had a negative impact, but also a positive impact in public service. I think that's all. Thank you very much.
Thank you very much. Okay, ladies and gentlemen, we are now at the end of this seminar. But before we close the room, we will have a photo session, an online photo session. So I hope all of you can turn on your cameras so we can have a screenshot of our faces. So even though we cannot have a good photo together in one room, we can have some pictures or memories that we can stay connected even though we are in separate places. Okay, are we ready, admin?
Oke.
Okay.
Yang pertama, 1,
Okay,
2,
the first one.
3. Sebentar, yang kedua.
Okay, the second one.
1, 2, 3. Siap.
Okay, is that all? Sudah selesai?
Ya, sudah.
Okay, thank you. I would like to thank all of the speakers of today's seminar for giving such amazing presentations that we can all reflect to. Hopefully we can have further discussion and work together in other occasions and hopefully directly in person, not in these Zoom rooms. Also to all of the participants, especially who have participated from the beginning till the end of the seminar. This seminar was also live on YouTube. So if you want to review the materials and rewatch the seminar, you can go to our YouTube channel. It's FHUB Official. There are also, I think, ada presensi, absensi yang sudah dibagikan di ruang chat seperti itu. And I think that's all for today's seminar. I am Aulia Nabila. Once again, thank you very much of this opportunity that has been given to me to moderate this seminar. And I think that's all. See you all very soon. I hope this pandemic can end very soon as well. Thank you. Good evening and good afternoon, everybody.
Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Thank you, everyone.
Thank you very much, Kak Dina. Thank you so much.
Thank you, Shinta.
Prof. Simon. Arista. Bu Dewi.
Terima kasih Bu Shinta and all speakers. Thank you so much.
Nanda, thank you very much.
Thank you. Nice meeting you all today.
Thank you, Wandina.
Sama-sama. Makasih kembali.
You can leave the room, Kak Dina.
Okay, all right.
Salam.